Hi guys. Today I'm going to look at a few more of the pre-trial motions. First of all, we'll look at the due process deprivations. So this one is from November 2025, and then there's a revised and updated one, and that one is from December 2025. So this is just to keep record of the things that have happened that have resulted in Edrick's due process being deprived. So number one is about the subpoena. So they sent Cameron Harrelson, who's podcast guy, a subpoena because he had a lot of information from the podcast that he did in 2020. So he interviewed lots of people and talked about different suspects and everything. And I'm assuming that's what the subpoena would have been for, so that they could get his research and stuff like that. And this is where we have attorney Tolley popping back in. So if you've watched any of my previous videos, Edward Tolley is a defence attorney who has been very active, obviously, in Athens, and he was the one that represented Mike Gaines. And then I saw that he was also running for commissioner of District 7 or something, and he's friends with all the people in the Big Boys Club. So anyway, Cameron had him as his attorney, and they filed a motion to quash the subpoena. And it says here, Mr. Faust was served by hand delivery on same date. Mr. Faust requested additional time to prepare an argument for the motion to quash subpoena. The Honourable Court denied same, directed Mr. Faust to proceed with argument on the surprise motion, and then denied same and issued a protective order for Mr. Cameron J. Harrelson. Mr. Faust preserves the error that he was denied his Sixth Amendment right to the compulsory process and the right to present a defence in regard to the surprise motion to quash subpoena. Mr. Faust preserves that same violates his rights under the Sixth Amendment of the United States Constitution. Number two was about another subpoena, and I think that was a specific hearing. And what happened is, at the beginning, the person who was subpoenaed wasn't present, and that it was significant because the hearing that she was subpoenaed for was to determine if the state would be able to present her statements under 413. I do have that in another video as well. So she wasn't present at the beginning, and then I think Cruz asked to enforce the subpoena, and because they needed her to put forth his defence in the hearing, and the Honourable Court denied enforcement of the subpoena in violation of his Sixth Amendment right to the compulsory process, right to present a defence, and right to effective assistance of counsel. So she did actually appear, but they just included that for illustrative purposes, because if she didn't appear, they wouldn't have cared. And I think this was on the same date. During Mr. Faust's motion for exclusion of other acts of evidence, The Honourable Court stopped him from asking questions relevant to the credibility of this person, which went to the heart of Mr. Faust's defence, and that the state did not meet its burden of other acts evidence by showing the preponderance of evidence that the alleged other acts occurred. And then Attorney Cruz tried to put his questions that he was going to ask on the record, and Lisa Lott said no. So this is where Cruz is going to file said questions instead. And if you want to read that, you can. Just pause that and read it if you would like to. And the next point is about something that happened a few times throughout the trial, but this was obviously in the pre-trial hearing. So when Sergeant Black was being examined, the state raised relevance objections, and then the court requested that counsel explain the relevance of his cross-examination in the presence of the testifying witness. So Cruz asked if he could either continue the line of questioning so that the relevance would become apparent, or proffer the relevance outside the presence of the witness. And the court denied both those requests. So, yeah, apparently that's not normal. Again, where the speaking objections are coming up again. And this is where Lisa Lott decides to say that speaking objections don't exist, and the state keeps on doing its speaking objections. And yeah, that happened throughout the trial as well. And then number 7, this is about the motion to exclude Larry Peterson and the hair analysis. So I have done a couple of videos on this, and this is just adding it into the document just to show that it was an issue. So this deprived Mr. Faust of due process of the law under the 14th Amendment, which includes a meaningful opportunity to present a defence, a meaningful opportunity to challenge the state's evidence, and procedures that are fundamentally fair. And this also deprived him of his Sixth Amendment right to effective assistance of counsel, because the purpose of pre-trial motions to exclude or admit evidence is to allow counsel to know what evidence is in or out. Because as they talked about a lot in this case, that because it happened so long ago, the case file was really, really big. There was a lot of evidence and lots of people that could possibly be called as an expert witness. So it's not really fair on the defence to have to prepare for everything when there's only they're just not going to have the time or the resources to do that. And yeah, further, due to the court refusal to rule on the motion, counsel cannot definitively structure opening statements or trial theory. So, and it denied Mr. Faust the opportunity to present his motion, a right that has not been denied to the state. So that's the one from November. And then there's a little bit of an updated one. December. I think this is just, so Cruz has obviously reviewed the transcript. And yeah, he received the motion that morning. And yeah, so they're just saying, yes, it is correct what we said in the last document. So yeah. And then I just thought I would have a look at the plea offer as well, because this is pretty ridiculous, if you ask me. So this is from Yamalama Ding Dong, and this was presented on January 12th, so just before the trial. It says, Mr. Cruz, you are representing Mr. Edrick Faust in case number blah blah, pending before the Honourable Chief Judge Lisa Lott in the Superior Court of Clark County. Honourable, I don't know. I'm offering the following to resolve the case. So, guys, if he pleads guilty as charged to all counts, then he'll get life with the possibility of parole. For the burglary, 20 years confinement, concurrent with count 1. This one, even though life imprisonment, I wonder if that one has parole or not then. Possibility of parole. And this is the one where, like, it's not even his DNA there. It's Chris Melton's, so what's that about? Arson. I don't think they definitely didn't present any actual evidence linking Edrick to the arson. They just, all they had was the DNA, full stop. And so 20 years plus 5. So basically 25 years minimum with possibility for parole. And it also says here, at the time of the entry of the negotiated plea, the state will have foregone the opportunity to file a notice of intent to seek death in this matter. So they're just dangling the little carrot. Yeah, we might let you out in 25 years. Maybe. We might just do the death penalty. I mean, really? Respectfully. Come on. I don't think so, buddy. So yeah. I wonder why he didn't take that deal.